Well, chief among those baying for Confederate blood was John Curtis Underwood, who would become Robert E. Lee's particular bête noire. Underwood was New York born in 1808 and New York educated at Hamilton College. But he had married a Virginian. In fact, Maria Underwood was a first cousin of Stonewall Jackson. And he set up a law practice in Clark County, sandwiched between the eastern wall of the Shenandoah Valley and Loudoun County. With Lincoln's election, Underwood was rewarded with a patronage appointment in the Treasury Department, and then a recess appointment as the federal district judge for the Eastern District of Virginia, which Congress then reorganized in 1864 as the Federal District of Virginia. On Friday, June 2nd, 1865, Underwood impaneled and charged a grand jury in Norfolk, which returned an indictment of Lee for treason, along with 36 other high-ranking Confederates who read like a who's who of Virginia's Confederate leadership. Solemnly, the indictment stated, "Not having the fear of God before their eyes, nor weighing the duty of allegiance, but being moved and seduced by the instigation of the devil, did maliciously and traitorously ordain and carry on war against the United States of America, against the Constitution, government, peace, and dignity, against the form and statute in such case made and provided." First of all, the Constitution's definition of treason is a very narrow one and is based on English treason laws dating back to the 1350s, which limited treason to attacks on the king's person or household, levying war against the king, or giving the king's enemies aid and comfort. Second, Lee would have to be tried in the jurisdiction where the treason occurred. The Constitution prefaces the section on treason with a section requiring that the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. And the Sixth Amendment adds that such a trial would have to take place in the district wherein the crime shall have been committed. That meant, at the least, that any trial of Lee would have to take place in Virginia. And while it might not have been difficult to create a cooperative grand jury in Norfolk, which had been under Union occupation since May of 1862, the wording of the Sixth Amendment seemed to require that a trial take place in Richmond, just as it had done in the Burr case. It would be a much more monumental task to find a civilian petit jury in Virginia which would vote to convict Robert E. Lee. Judge Underwood certainly understood that this would be one of his most formidable obstacles. Unless it is what might be called a packed jury, 10 or 11 out of the 12 in any jury, I think, would say that Lee was almost equal to Washington and was the noblest man in the state. And then thirdly, the Chief Justice of the Supreme Court, Salmon P. Chase, would not cooperate. That Chase would refuse to participate in his auxiliary role as a federal circuit judge so long as military tribunals were operating anywhere within a given district. While military authority was supreme in the South, Chase explained, no justice of the Supreme Court could properly hold a court there. And by tradition, Chase's circuit responsibilities as Chief Justice embraced Virginia and North Carolina. Without Chase's participation in a capital case, Judge Underwood would have to try Lee's treason case by himself. And that would produce a verdict of, at best, dubious legality. And then thirdly, there is the matter of Lee's own self-defense. 2 weeks after Judge Underwood's grand jury indicted him, Lee shrugged off his pessimism and began asserting a more defiant tone. To his cousin, Martha Markey Williams, Lee declared that he was aware of having done nothing wrong. That sense of nothing wrong grew out of a theory of citizenship, which in turn was based in a fundamental ambiguity in the federal Constitution. Nowhere in the Constitution, as it was written in 1787, is the concept of citizenship actually defined. In the 5 places where the Constitution refers to citizenship, it speaks of citizens of the states and citizens of the United States. But the Constitution makes no effort to sort out the relationship between the two, leaving the strange sense that Americans possessed a kind of dual citizenship in their native state, as Lee called it, and in the Union. This played directly into the larger pre-war argument that the Constitution had neatly divided sovereignty between the states and the federal union. Lee had no trouble arguing that Virginia and the other rebel states were merely using the reserved right of state sovereignty when they seceded. And in my view, Lee reasoned, that meant that the action of the state in withdrawing itself from the government of the United States required its citizens to act with it. The Act of Virginia, in withdrawing herself from the United States, carried me along as a citizen of Virginia because her laws and her acts were binding on me. In the event, of course, the Civil War had exploded that theory by sheer force. The war, Lee explained to his nephew, Edward Child, originated from a doubtful question of construction of the Constitution about which our forefathers differed at the time of framing it, and it had now been settled by the arbitrament of arms. But neither Lee nor any other individual Confederate could be called a traitor for having done so. The state was responsible for the act, he explained, not the individual. Lee's citizenship argument was an ingenious one, and it would become a standard opening for other high Confederate officers. But there was a little-known flaw in the application of this reasoning to Robert E. Lee, and that flaw ran back to his resignation from the U.S. Army at the opening of the war on April 20th, 1861. He submitted his resignation, an act which he believed released him from his personal oath as a soldier and returned him to the simple status of a civilian. 2 days later, on April 22nd, he was in Richmond. The next day, April 23rd, he assumed command of all of the military forces of Virginia. So it came as an unwelcome surprise to learn through his son Custis that the War Department's acceptance of his resignation had not taken place until April 25th, by which time he was already in active command of the Virginia forces. I resigned on the 20th and wished it to take effect on that day, Lee fumed. I cannot consent to its running on further.